Ever signed something without really knowing what you have agreed to? Well, the law says that might even not count as consent. Let us find out why free consent makes a big deal in contracts. Hi, I'm Ashik Hanchandani and this is Logical Lens, and here we connect law to people one basic at a time. And today's topic is all about free consent under Indian Contract Act. So let's get started. Ever signed something without really knowing what you have agreed to? Well, the law says that.
What is consent? Consent is when two or more people agree upon the same thing in the same sense, or as we call it legal Latin, consensus ad idem. Think of it like this: if I'm selling you my red Swift parked outside and you're agreeing to buy that exact car, perfect. But what if you think I'm selling the blue one? We are on not on the same page. And that's the first part. But just agreeing isn't enough. The law demands that this consent be free. Let us see what it really means. Section 14 says consent is free when it's not caused by coercion, undue influence, fraud, misrepresentation, or mistake. The moment any of these creep in, the consent is defective and the contract's future is shaky. So, why does the law care so much about keeping the consent free? Let's find out. Why free consent matters. Free consent is the backbone of a fair contracts. It's even mentioned in the section 10 as a requirement for validity. Without it, we risk one party being trapped in an unfair deal. And that is why the law gives us clear rules to protect it. And those rules, they start with understanding the five things that we can ruin free consent. Let us go through them one by one. Let us now understand the essentials of a free consent. So the first essential that we're going to talk about is coercion, that is mentioned under section 15. It basically means when someone forces another into a contract by doing or threatening to do something. To understand this better, we have a classical case, Chikam Ammiraju versus Chikam Seshamma, where a husband threatened suicide unless his wife signed a property transfer. The court held even suicide threatens count as coercion. And here's a simple example to understand is A threatens to lodge a false criminal case unless B signs to a loan security. B signs. Consent over here is caused by coercion. The second essential is undue influence, where one party is in the position to dominate the will of another and uses it to obtain to an unfair advantage. In the famous case law Manu Singh versus Ummat Pandey, it was held that relationship of trust misused is contract voidable. Example to undue influence is when a doctor persuades a seriously ill patient to sign an exorbitant free agreement right before the surgery. Moving on to the third essential, that is fraud, which is mentioned under section 17, tells us about deceit, that is false statement known to be false or made without belief in its truth, intention to deceive someone, or causation of consent. The famous case law Derry versus Peak tells us about a company claimed it could run trams using steam power without official approval. That wasn't true, but the directors genuinely believed they would get permission. The court said there was no fraud here, but laid down the test. Fraud is a false statement made knowingly without belief it in its true or recklessly. Examples to fraud is active concealment and half truths, and exceptions to it is when silence isn't fraud. Basically, no general duty to disclose unless duty to speak. Silence is itself deception, circumstances change, or half truths are told. Moving on to the fourth essential, that is misrepresentation. It happens when a false statement is made innocently, but it still induces the other party into a contract. The difference: in fraud, you lie knowingly. In misrepresentation, you make a mistake. The effect can still be serious, but the intention is absent. But sometimes neither lies nor mistakes are issue. It's both the parties believe something that turns out to be wrong. That's a mistake in law. Mistake means an incorrect belief or something essential to the contract. For example, if both the parties share the mistake, the agreement is void. Second, mistake of law, no relief. And third, one party mistaken, usually still valid. Why? Because ignorance of fact is understandable, but not the law. Classic example to understand this better would be cargo believed to be an en route had actually perished before the contract was made. Whereas in Phillips versus Brooks, the court held that a face to face sale to a road wasn't void for mistake, it was voidable for fraud. Now that we have seen all five mitigating factors, let's see what they mean for all the fate of a contract. Effects of contracts when consent isn't free. Here's how the law treats defective consent. Coercion and undue influence, voidable. Fraud and misrepresentation, and sometimes damages too, voidable. Bilateral mistake of fact, void. Unilateral mistake or mistake of law, generally no relief. So here's the recap. Consent means agreeing on the same thing in the same sense. Free consent means no coercion, undue influence, fraud, misrepresentation, or mistake. To understand them better, we have the key cases. And yes, some contracts survive even without free consent, like certain unilateral mistakes.
And that's free consent made simple. If you have found this video helpful, don't forget to like, share, and subscribe to Logical Lens. Until next time. And that's free consent made simple. If you have found this video helpful, don't forget to like, share, and subscribe to Logical Lens. Until next time. And that's free consent made simple. If you have found this video helpful, don't forget to like, share, and subscribe to Logical Lens. Until next time. And that's free consent made simple. If you have found the